Excelencias,
Your Excellencies, distinguished delegates, I call to order the 22nd session of the Assembly of States Parties to the Rome Statute of the International Criminal Court. It is a great privilege and an honor for me to welcome you all to this meeting at the United Nations headquarters, which we are holding without the restrictions that we encountered in 2020 as a result of COVID. I would like to thank the USG for Legal Affairs and the UN Legal Advisor, Mr. Miguel de Suárez. I'd like to thank him for being here. This once again bears witness to the cooperation between our two institutions. We have an ambitious agenda before us. We will hold elections to various high offices, 6 new magistrates of the court, 6 members of the Budget and Financing Committee, as well as the President, Vice Presidents, and the Bureau for this Assembly for the forthcoming 3 sessions. We will also be adopting the budget for 2024. In addition, we will be discussing the important issue of cooperation and the review of the Rome Statute system. Before continuing, I would invite you to stand and to honor a minute of silence for prayer or meditation, in particular thinking about the victims of crimes around the world.
muchas gracias.
Thank you very much.
Into English. Before going into the substantive issues, I would like to provide you with some practical information. We also have to take some purely procedural decisions to ensure the proper functioning of this assembly. Following a drawing of lots at the 8th meeting of the Bureau on 7 September 2023, in accordance with decision ICC ASP1 decision 4 of 3 September 2022, the delegation of Jordan will take the first place to my right, with the other delegations following in English alphabetical order. However, for practical reasons, while we will hold the election of 6 judges, the state parties will be placed in English alphabetical order, starting with Afghanistan. Once the elections are over for our general debate and the continuation of our work, we shall revert to the usual configuration for the sittings of the Assembly. Due to the limited capacity of the room, each state party will be allocated 2 seats. The other delegates from state parties are invited to sit in the reserved seats at the back of the room. For observer states, as well as other observers, participants, and guests, in accordance with Rules 92, 93, and 94 of the Rules of Procedure, seats are also reserved at the back of the room, and NGOs are invited to take their seats in the gallery. Observer states. Distinguished delegates, in accordance with Article 112, paragraph 1 of the Rome Statute, states that are not parties to the statute, but have signed either the statute or the final act of the Rome Conference may participate as observers in the Assembly. Observer states are allowed to participate in the deliberations of the Assembly, but may not participate in the taking of decisions. States that are not parties to the Rome Statute and that have not signed the final act or the statute do not have observer status. Rule 94 of the Rules of Procedure provides that at the beginning of each session of the Assembly, the President may invite those states to be present during the work of the Assembly, subject to the approval from the Assembly. I propose that the Assembly invites the following states which do not have observer status to be present during the Assembly's work: Bhutan, Democratic People's Republic of Korea, Equatorial Guinea, Eswatini, Lao People's Democratic Republic, Lebanon, Mauritania, Federated States of Micronesia, Myanmar, Niue, Palau, Papua New Guinea, Rwanda, Somalia, South Sudan, Tonga, Turkmenistan, and Tuvalu. May I take it that the Assembly wishes to invite these states to be present during its work? I see no objection. It is so decided. As already mentioned, seating has been reserved for observer states and invited states. Seating has also been reserved for NGOs invited under Rule 93 of the Rules of Procedure. Now we're going to turn into the adoption of the agenda. Distinguished delegates, the provisional agenda is contained in document ICC ASP22/1, and an annotated agenda is contained in document ICC ASP/22/1 Addendum 1. May I take it that it is the wish of the Assembly to adopt the agenda as contained in document ICC ASP/22/1? I see no objection. The agenda contained in document ICC ASP/22/1 is adopted. Excellencies, distinguished colleagues, I have the honor to report on the activities carried out by the Bureau of the Assembly this year. In the interest of time, I will only highlight some aspects contained in the full report to be included in the official records of this session. I wish to begin by expressing my sincere gratitude to the two vice presidents of the Assembly, Ambassador Katerina Sekwensova from the Czech Republic and Ambassador Robert Ray from Canada, for their hard work and warm support to me, the Bureau, and as coordinators of the Hague and the New York working groups, respectively. Allow me to also express my deep appreciation for the work carried out by the working groups and for the facilitations and focal points in the fulfillment of their mandates. I also wish to recognize with gratitude the great support provided by the Secretariat to all of us in New York and The Hague throughout the year. Excellencies, distinguished representatives, the Court has a crucial role to play within an emergent global system of justice. I have continuously emphasized that for the Court to discharge its mandate, considering contemporary challenges, it is imperative to continue deploying efforts to strengthen its functioning, increase cooperation and support for its activities, and enhance the universality of the Rome Statute. This year, we have indeed continued to assign priority to the strengthening of the Rome Statute system through the work of the review mechanism and other initiatives. I wish to recognize the key role played by the state party representatives, Ambassadors Michael Kanu from Sierra Leone and Paul van den Ijssel from the Netherlands, and the country focal points of the review mechanism, as well as the important contribution to their work by Assembly mandate holders. They have all contributed to significantly advancing the work of the Assembly on the independent expert review recommendations. Our focus now turns to the future of this review. Discussions in this regard will continue during the Assembly, including in particular at a plenary session to be held on 13 December. I encourage you all to participate in these discussions, as we must ensure that the pending issues are addressed in an appropriate way. A crucial aspect of strengthening the system, to which I and the Bureau have given huge priority this year, is the improvement of processes for selection of officials of the court. At this session, we will elect 6 new judges, a key role for the Assembly. I wish to acknowledge the important contribution by the Advisory Committee on Nomination of Judges, the ACN, which has provided a thorough report of a technical character containing detailed information and analysis on the suitability of each of the candidates. Public roundtables with all candidates have also been improved following the mandate of this Assembly, with modalities that were determined by the New York Working Group. These were held on 6 and 7 November 2023 at the UN in both working languages of the court, and all candidates took part in person. I am confident that these roundtables, as conducted, will prove useful for state parties in their considerations for the election of judges. As part of these efforts to improve the selection of judges, the Assembly has requested the ACN to prepare guidelines for national-level nomination procedures next year. I urge all state parties that have not yet done so to submit information on their national nomination procedures as soon as possible to enable the ACN to effectively carry out its mandate. In addition, I wish to underline that the judicial candidates at this election, for the first time ever, have been subject to a due diligence procedure approved by the Bureau in February. The procedure benefited from the experience garnered from the 2 previous ad hoc due diligence processes for the elections of the deputy prosecutors and registrar, respectively. The IOM provided invaluable assistance to the design and implementation of the process in consultation with the ACN. The IOM also provided essential advice in the discussions on the establishment of a permanent due diligence procedure for all elected officials of the court, which has been submitted for consideration by the Assembly at this session. I thank the co-facilitators and all those involved in this important work, which will serve to strengthen Assembly elections in the future. I will now continue in French. Excellences, distinguished...
Your Excellencies, distinguished delegates, strengthening cooperation to the court's activities, as well as improving universal participation within the Rome Statute system, have remained critical priorities for the Presidency and the Bureau of the Assembly. Support and cooperation are necessary for the entire system, and this includes the Special Trust Fund for Victims, which plays a critical role in providing reparation for harm suffered by victims and societies affected. I personally have made considerable efforts throughout this year to make the fund more visible, to ensure that it has greater support. I would like to take this opportunity to thank the board and the fund secretariat for their continued efforts to improve the situation. States and civil society have a critical role to play to ensure that the court benefits from their cooperation and their support. Throughout the year, I have actively contacted civil society organizations to include their view within the work of the Assembly and the Court. I would like to express to them my recognition for their support, their availability, and their candor during the discussions on the issues and challenges that the Court and the Assembly have to overcome. This year, we devoted a great deal of our time and our energy to commemorating the 25th anniversary of the adoption of the Rome Statute, a unique opportunity for us to spread awareness about the Court's work and to promote support for the institution. To this end, the Presidency of the Assembly has established, working with various partners, a commemoration event to mark this anniversary. The commemorations kicked off on the 12th of July this year in The Hague and continued to the 17th of July at the United Nations headquarters in New York, where we discussed together the Court's strategic vision for the next decade, how to ensure consistent, lasting support for the Court, as was recommended by the report of the group of independent experts. Discussions on this same issue continued in October in a symposium organized by the Syracuse Institute for International Criminal Justice and Human Rights with the Assembly's support. The commemoration events will be concluded at this Assembly session. Your Excellencies, distinguished delegates, in the current global context, we must ensure that the Court, its staff, and all of those who work with it are appropriately protected. The Presidency and the Bureau believe that this year, this question is of paramount importance. The Court exercises its competence in situations where there is continued violence, and the polarization that exists within the international community can have repercussions on the cooperation and support from which the Court can benefit. It is therefore critical that the Assembly strive to protect the Court from all attacks and to ensure that its integrity, impartiality, and independence are upheld. This year, we have applied this strategy to respond to threats and attacks that the Bureau adopted in 2022. On several occasions, the Presidency rejected procedures begun against the prosecutor, the President, and 6 judges, and the Court was targeted by a cybersecurity incident in September 2023. I once again reiterate our unwavering support to the Court, and I strongly support its elected representatives. I also call on states, civil society, and the international community to condemn these attacks and to fully cooperate with the Court to strengthen its protection, independence, and impartiality. Significant measures have also been taken this year to strengthen the security of participants in the Assembly. On the 4th of October this year, in line with the commitment that I undertook during the closing plenary session of the 21st session, the Bureau adopted the guidelines to strengthen the security of participants at the Assembly's ordinary sessions and its parallel and its side events. These guidelines aim to guarantee a safe, secure and open environment, as well as fruitful dialogue in the Assembly's meetings and its side events. They also stress the importance of ensuring freedom of expression and inclusive expression of one's opinions before, during, and after the Assembly sessions. These guidelines are being applied for the first time in this meeting, and I would encourage dialogue to continue to strengthen this document going forward. Your Excellencies, distinguished delegates, in order for this system, the Rome Statute system, to be effective and legitimate, we need to aim for universality. The Court is an institution of last resort, but it cannot contribute to the emergence of a global justice system unless it is able to intervene in all situations in the same way. The quest for universality is a shared responsibility, shared between the Court and the Assembly. From this point of view, the Presidency, working with the Court, has made significant efforts to strengthen universality, with the support of the focal points that have been designated to that end, that is to say, the Netherlands and the Republic of Korea, as well as with the support of civil society, particularly the global action of parliamentarians. We would like to express our thanks to all of those who have taken part in this important enterprise. I would like to conclude the current oral report by very warmly welcoming Armenia, which gave its instrument of ratification of the Rome Statute on the 14th of November this year. They will become a state party on the 1st of February 2024. On behalf of the Assembly, I would like to congratulate Armenia upon this important decision. Can I take it that the Assembly wishes to take note of the Bureau's oral report? I don't see any objections. It is so decided. And we have therefore concluded our consideration of Agenda Item 10.
And now I invite the UN Legal Counsel, Mr. Miguel de Serpa Suarez, to take the floor from the rostrum.
Excellencies, distinguished delegates, ladies and gentlemen, I am pleased to be with you today on this occasion and to deliver this keynote address on behalf of the Secretary General, who is currently in Dubai for the COPs on climate change. This July, we celebrated 25 years since the adoption of the Rome Statute. And next October, we will celebrate 20 years since the conclusion of the relationship agreement between the United Nations and the Court. So we are in a special time, a time when we must take pride in what we have achieved, reflect on what we have not, and work on what we still have to accomplish. At this moment, I feel tempted to fall back on the history of what brought us here. Excellencies, distinguished delegates, 25 years ago, on the 17th July of 1998, around midnight, in the main conference room of the Food and Agricultural Organization in Rome, in the presence of delegates from around the world, corridors crowded with diplomats, ministers, legal experts, United Nations staff, NGOs, and media representatives, in an atmosphere mixed with apprehension and excitement, all waiting to hear the president of the Rome Diplomatic Conference declaring that the Rome Statute of the International Criminal Court has been adopted. I am sorry I was not there. I know my friends Sylvia and Renan participated in this festive moment. Now, by that adoption, and on the threshold of the third millennium, the international community sent its warning. We will no longer tolerate those who outrage human conscience. The establishment of the court was a major breakthrough in the enforcement of international criminal law. It is established out of a long endeavor for a permanent, effective, and politically uncompromised system of international criminal justice. It is created to ensure stability in international criminal jurisdiction and consistency in international criminal jurisprudence. The establishment of the court was the apex of a long process that started at Nuremberg and Tokyo and developed by the ad hoc tribunals for the former Yugoslavia and Rwanda. The United Nations was the forum for the preparatory work of the Rome Conference, initially through the International Law Commission and subsequently through bodies convened by the General Assembly. Negotiations contained extremely complicated legal issues and concepts that required the support of an objective body of expertise, which the United Nations provided through its Office of Legal Affairs. Ladies and gentlemen, this court is established as a challenge to impunity. It is created to stand impartial and indifferent to status. It is then to be expected that the court may come under attack. Its authority may be challenged and its operations may be targeted. At these moments, it is our duty to defend the court's independence. Judicial independence is the crown jewel of our international legal system. It guarantees that rule of law will not be eroded by the pressures of politics, and basic legal protections won't fall victim to the passions of the moment. The court's independence is an obstacle to impunity and the necessity for accountability. I thus send from here a firm and unequivocal message. Attempts to intervene in the work of the court are unacceptable. Attempts to intimidate its officials cannot be tolerated. Excellencies, the independence of the court is not only a prerequisite for its functioning, but it is also a constitutional aspect of its establishment. You, the state parties, play an important role in the effective operation of the court. The proper finance and administration of the court depends on your decisions. All key matters, including the election of judges, which happens to be on your schedule this session, are exclusively in your hands. I thus wish you a successful session and election process, a process which I trust will bring to the bench judges who would bring justice to the voiceless. Ladies and gentlemen, the court is established within an international system whose center of gravity is the United Nations and whose primary legal instrument is the Charter of the United Nations, a fact that led the ad hoc committee on the establishment of the court to envision back in 1995, and I quote, a close relationship between the proposed court and the United Nations was viewed as essential condition of the universality and moral authority of the new institution, end of quote. As a result, our relationship agreement was concluded in 2004, and my office was designated by the Secretary General to advise and act as a focal point for our cooperation. The United Nations and the Court are separate institutions. They respect each other's independent status and mandate, and they cooperate with a sense of common purpose. My office remains committed to carrying out its central role, a role that is guided by the relationship agreement and the purposes of the United Nations. For almost 2 decades, my office has been advising various United Nations bodies in the field and headquarters on countless cooperation requests coming from the court. We have been supporting the court with administrative and logistical assistance. We have been providing numerous documents and information not available to the court from other sources. We have been facilitating interviews and testimonies of United Nations personnel whose professional and field expertise render them invaluable source information. We have been engaged in concluding supplementary cooperation agreements between the court and numerous United Nations bodies in line with the relationship agreement to expedite and streamline our support to the court. Senior officials of United Nations entities, including myself, are in a continuous dialogue with the court's principles to reinforce existing realms of cooperation. Now, this is only a glimpse of our support to the court. It's full scale, it's impossible to measure or quantify, most of which has been taking place outside the public limelight for almost 2 decades. We have been putting in these many hours of hard work out of a strong belief that justice is not automatic. Justice is a result of action. Ladies and gentlemen, we have achievements, but we have grave challenges. As we see, conflicts continue to rage, where violence begets further violence, and each slaughter is the parent of the next. Men, women, and children no different than us, with names, faces, and many joyful life events ahead of them. They're dying, displaced, and living in fear. The graveyards display unspeakable brutality. That demolished homes reveal our capacity for unmatched destruction. Compliance with basic humanitarian protections is becoming elective. Our core values, the very foundations of our international legal order, are being shaken. We are in a time when demand for accountability has never been greater. We may not be able to eliminate man's capacity to do evil, but what we can indeed do is to support the universality of the court, because only then will innocents of brutal conflicts at least know that they too may sleep under the cover of justice. That is why the Secretary General has been calling upon member states to cooperate with the court and to join the Rome Statute for those states that have not. The United Nations stands firm in supporting the court, not only because peace can be broken by impunity, but also because that is what we owe to the victims. We, the international community, and behind us all the defenseless, hope and support the court to achieve its mission in dismantling impunity. Excellencies, distinguished delegates, we have achievements, we may have setbacks, but indeed we are not done. We can acknowledge the eventuality of conflicts and still strive for justice. We can confess the intractability of the war machine and will strive for accountability. The strength of the court depends heavily on the support it gets from you, the states parties. Challenges are immense and expectations are high. I hope that one day we can tell our children a different story, one that speaks about the cause of humanity, one that makes wars less likely and impunity less acceptable. Thank you.
I thank the UN Legal Counsel for his statement and for the cooperation extended to the court, including for the holding of this assembly on UN premises. And now we turn to agenda item 11, report on the activities of the court. The report is contained in document ICC ASP22/22. We are honored to have the President of the Court, the Prosecutor, and the Registrar present today. On behalf of the Assembly, it gives me great pleasure to extend to them a warm welcome and to assure them of the continuing support of the Assembly in the discharge of their respective responsibilities. The Assembly is aware of the enormous responsibilities inherent in your offices. I will invite the President of the Court and the Prosecutor to address this plenary today. The Registrar, Mr. Osvaldo Zavala Giler, will deliver remarks to the Assembly when we shall take the agenda item 16, consideration and adoption of the budget for the 22nd financial year. Now I shall first give the floor to the President of the Court, Judge Piotr Hofmansky.
Madam President of the Assembly, Honorable Ministers, Excellencies, Mr. Legal Counsel, Mr. Prosecutor, Madam Chair of the Board of Directors, Mr. Registrar, ladies and gentlemen. Public speaking can make anyone a bit nervous, especially when addressing a large, important, high-level meeting such as this one. But I assure you that I was much more nervous 9 years ago when I was in the same building as a candidate for ICC judge. And I can guess that there are many persons in this room today who are experiencing similar nervousness or excitement. Don't worry, I will not discuss the judicial elections any more than that, except to say that I am confident that the Assembly will elect the best possible candidates. I am also not going to repeat today the contents of the Court annual report on its activities. Instead, I would like to use this opportunity to share some reflections as my term as judge and the President of the Court is coming to the end on March 10th next year. Without doubts, one of the dominant themes during my presidency was the review process. Especially in 2021 and 2022, the assessment of the IO recommendations required considerable time and efforts from the Court on top of every very, very heavy judicial workload. But it was worth it. I firmly believe that the Court has become a stronger institution as a result. The review has been an excellent example of the Court and the Assembly working together in a constructive manner. There were a few tricky areas where we had to walk a fine line in order not to undermine the Court's independence, but I believe it was successfully done with the help of goodwill on both sides. One of the most significant results of the review process concerns workplace culture at the ICC, and during the two last years we have done a lot. We recruited the ombudsman, we updated and also the focal point for the gender equality. We updated the Court's policies on harassment, discrimination, misconduct, sexual abuse and disciplinary procedures. And the judges amended the Code of Judicial Ethics to subject themselves to these policies as well, to the extent allowed by the Rome Statute. We adopted the court-wide strategy of gender equality workplace culture. We conducted detailed surveys and evaluation to get a realistic picture of what the staff experience is. And we made ethics and standards of conduct one of the top priorities of the Court's new strategic plan. I would like to stress that these cannot be just one-off measures. Making and maintaining the ICC a safe and rewarding workplace for everyone requires a permanent commitment. This really is crucial. Everyone must be treated with respect, and everyone must be accountable for their actions. Madam President, another major stand of the review process that kept me very busy was, of course, of the Part A report that contained the judiciary. I'm very happy to state the assessment of all judicially-related recommendations was finalized earlier this year, and many of them have already been implemented as well. Much of this tied together perfectly with the long-standing efforts of judges on enhancing the court's judicial process. The work has been largely built around annual retreats, where the 18 judges meet to agree on measures to harmonize working methods and expedite proceedings. During the last 3 years, much has achieved in this respect, and I can only highlight a few key outcomes, as such a model decision and directions the conduct of the proceedings, the unified approach to victims' applications, so-called the ABC method, several measures expediting the pre-trial to trial transition, and guidelines on dissenting and separate opinions. In addition, the judges have worked closely with the Advisory Committee of Legal Texts and Assembly of State Parties Study Group of Governments, as well as the Working Group of Amendments on a number of important amendments proposed that are now before the Assembly. Madam President, on defining feature of my term as President has sadly been attacks against the ICC. I became President at the time when the previous prosecutor in the ICC was still the subject of unacceptable measures imposed by the United States. Fortunately, these were withdrawn soon thereafter. But as you all know, the court has since become the target of new threats and attacks. Notably, the authorities of the Russian Federation has initiated criminal proceedings against 6 ICC judges and the ICC prosecutor, placing the individuals, including myself, on the wanted list. All of this because we are fulfilling our mandate, whether performing judicial or administrative functions. This is unprecedented attack on the judicial independence and the international level. I am very appreciative of the strong support we have received from our state parties and others in the face of these troubling measures. That support will remain critical for the foreseeable future. I am also gravely concerned by a recent cyber attack against the court's information system committed with the objective of espionage. I would like to thank the Netherlands, our host state, for the excellent support it has provided for the immediate and forceful steps the court took to respond to the cyber attack. Under the Registrar able leadership, we are now upgrading and enhancing our digital system to make them more resilient. There is no doubt the attempts to undermine the ICC will continue in many forms. There will always be resistance against the court mandate from someone and somewhere, but we will remain resilient. We will not be intimidated. We cannot compromise justice, and we cannot compromise the rule of law. On that note, I want to underline the paramount importance of the court's independence. This is fundamental value which must not only be respected, but actively safeguarded at all times. The whole point of having a court, a judicial body, is to have an independent, impartial arbiter to apply the law which the legislators, in this case states, have adopted. A fundamental aspect to that division of task is the separation of powers. On certain issues, we must always step an appropriate distance. not just between the court and others, but also between the judiciary of the court and the office of the prosecutor. As a court, the ICC is different from most other international organizations because states are technically not part of the organization, and even less so in charge of its activities. And yet we need your support and cooperation. But it is important that that support is not made conditional upon the court acting in a specific way in the matters that fall under judicial and prosecutorial independence. Indeed, support for the court should be support for the institution and all its activities as a whole, and never just for one particular investigation or specific cases. That would be a slippery slope, and it would risk damaging the way the court is perceived. I have always said that the ICC is the court for everybody. We must live up to that promise, and that's not an easy task. Look at the state of the world. In my 3 years as president, the global news have been filled with armed conflicts and widespread suffering of civilians in different parts of the world under the ICC's jurisdiction. Let's face it, this is a test for the court. It is a test for the Rome Statute system. The eyes of the world are upon us. The expectations are high. This is a huge challenge. The ability of the Rome Statute system to grow and to gain more global support depends on our ability to deliver tangible results in an independent and impartial manner. Equal standard must be applied to every situation and to alleged perpetrators on all sides in any investigation. This is critical for the ICC's credibility as a court of law. Madam President, when I became president of the court, I made promoting universal ratification of the Rome Statute one of my priorities. Perhaps I was too optimistic, and I had hoped of seeing many countries join the treaty during my term. However, I am absolutely delighted that the Republic of Romania finally brought us the fantastic news and the first new ratification since 2019. Congratulations, and thank you, Armenia. To all other states present, I say, please redouble your international efforts to promote universality of the Rome Statute. We need the collective push of the ICC community to encourage others to take the courageous step that Armenia has just taken. The road ahead us must be long, and the journey may be slow, but we must not abandon the goal of universal ratification. Madam President, Excellencies, ladies and gentlemen, my overreaching goal of President and Judge of the ICC has always been clear: strengthen the rule of law and focus on the court's core mandate, which is to deliver justice, tangible justice, justice which is fair to both parties and all participants of the proceedings. Justice is a team effort. None of us can do it alone. On that note, I want to take this opportunity to thank everyone at the ICC I have worked with, my fellow judges, the other elected officials, the staff of the court, and the Council of the Defense, and for victims. I thank the victims and witnesses who have bravely participated in the proceedings. I thank the states and the international organizations that extended crucial support for the court's operation. I thank the countless civil society organizations whose advocacy and commitment is crucial for the vitality of the Rome Statute system. I thank the academic community for the important contributions to the legal and intellectual discussions on the ICC. I thank my friends and my family for always standing with me. And I thank the Assembly of State Parties for all its support for the court during my term as president, under the excellent leadership of President Silvia Fernandez. Silvia, it has been a great pleasure to work with you. Although I will truly miss you, I do also look forward to working with the new President of the Assembly during my last months at the ICC. And I wish her, as well as my successor, wherever it may be, the best of luck and success for the next 3 years. Please take good care of this precious court of ours. Thank you.
I thank President Hofmansky for this important statement and for sharing with us his reflections, thoughts, and personal feelings about his 3 years' experience as President of the Court. It has indeed been a pleasure to work with you as well, and I thank you very much for sharing these views with us. And now I invite the prosecutor of the court, Mr. Karim Khan, to address the Assembly.
Bismillah ar-Rahman ar-Rahim, Madam President, Silvia Fernanda de Gamendi, Vice Presidents, members of the Bureau, I start by applauding you as you come to the end of your 3 years on your service to the Court and international justice. Under Secretary General and Legal Counsel to the United Nations, Secretary General, my dear friend Miguel Suarez, thank you so much for your leadership, your support, independent to the United Nations, but upholding these fundamental principles of the Charter. President Hofmansky, thank you for your service to the Court over 9 years. The sincerity that you have displayed and that was apparent just now is sincere, and I think we all owe you a gratitude, as we do for all of the judges of the ICC that I recognised, and to my friend, the Registrar, who's made a storming start under challenging circumstances. I also want to pay acknowledgement to him. Excellencies, civil society representatives, and my friends, I think every night and every morning when people turn on their television screens, tears are shed, because we see pictures of hell visited upon us in our living rooms. And those tears are nothing compared to the pain and the bloodshed that too many millions are feeling around the world. This is a perilous moment by any yardstick. I said that actually, I think almost verbatim, when the Ukraine situation kicked off and we started seeing the results that we were investigating. And I think now it's not hyperbole to say that we've gone beyond the precipice. We're in danger of freefall. And we are searching for some guardrail, some handle to hold on to prevent things descending even more for our fellow men, women, and children around the world. And so the opportunity to speak to you all today is really a somber one, because it's framed by the needs of the hour, the hopelessness and heartbreak of millions, and yet at the same time, in the same space, we have clearly, with great clarity, a need, a demand, an imperative that the Rome Statute is given effect to, that the international structures that have been created in the shadow of the Shoah, of the Holocaust and the Second World War can step up and sustain the tragedies that we see. And it's critical at this particular moment, and is something that should be reflected upon in the seriousness of our discussions these next 10 days or so, and in your decisions as the ASP, as to how do we live up at this moment to the very real challenges that are abounding the world. I think we have to prove the relevance of the law, not fine words, to those that need it the most. I arrived in New York yesterday from Israel and also Palestine. And I heard very clear messages from victims in Ramallah, in Tel Aviv, in the various kibbutzim that I visited, whose tears were real, whose anger was real, whose heartbreak was deep. And many believe that the institutions created have already irredeemably failed, because they see these structures and they believe, part of them believe in this wonderful, necessary creation, the United Nations. They believe in the aspiration of an international criminal court that will be a court of last resort, finding justice, and yet their lived experiences show for far too many they feel invisible, they feel voiceless, they feel too small to somehow count in the big power dynamics that straddle the world. And I told them I understood, because we have to understand that perspective. Unfortunately, there's no monopoly on suffering. And the suffering of one community anywhere in the world can't drown out the suffering of others. It's the terrible legacy of our times that suffering is too rampant and unaddressed. It leads to bitterness, it leads to heartbreak, it leads to distrust, and failure collectively of states as the anchor of the international system to grapple the nettles of peace and the rights of the individual are creating an ever greater yawning gap. And as we see on our television screens, as brothers and sisters caked in dust pull out brothers or sisters or family members from rubble and kiss their tummies of little babies and kiss their feet, as fathers run in barefoot, holding a beautiful little child and saying, can she be saved? We see this in very stark terms. What is the result of the words we speak today? What are the results of the international institutions that have been built in the shadow of the Holocaust? What do we say to the promise of never again? What do we say to those hostage families that were taken on the 7th of October, who every moment also are waiting for their loved ones, wondering what condition they are in? Are they alive or not? Have they been killed in the bombardment? And for families in Gaza, what do we say? How do they feel if they come from the rubble, injured and in life, and are taken to hospitals that don't have the basics for healthcare? I think, as we sit in the comfort of this hall, remembering the legacy after the failure of the League of Nations to prevent the Second World War, and rising as a phoenix was the United Nations and this wonderful charter that underpins, as the Under-Secretary General says, every single international institution, including the ICC. What is our answer? What is our grading? How have we done? This is not a cry for despondency and despair. It's a cry for action, determination, that the world we see now, the world that so many encompass, is not the world that has to be our legacy, our inheritance to our children. My prayer, my humble prayer, but a very profound prayer, is let us not even utter the word justice during this assembly of state parties without vividly seeing these children innocent around the world. Let us not utter the word justice without bearing in mind that people are wondering what on earth is happening to their father, their mother, their loved ones that are hostages. Let us not utter the word justice without remembering that we must have a bandwidth that is wider than just Ukraine or wider than just Palestine or Israel. What about the hell that is happening in Darfur? If we are true to the promise that every life matters, we need to find a way to grip and to tackle and to be relevant to people that are voiceless, that are invisible, and that very often have been marginalized for a long time. I was deeply and personally affected by meeting the victims in Ramallah, people from Gaza and the West Bank that have lost indescribable amounts. And yet, amazingly, they came to see me. And they spoke with me. I had the honor of meeting them. And the same applies to those wonderful people I met in Israel. Israel is not a state party. But those individuals that I met in the various kibbutzim or in Tel Aviv that engaged with a foreign prosecutor from a court in The Hague, believing that justice is every person's birthright, must leave an indelible effect. But I was clear with them that the ICC, the law that was passed in Rome, is the birthright of humanity. That it's the right of people, not as some charity that we dispense, not some aid convoy that we ride up in. It is a right based on their God-given rights as being children of God and by being humans. This goes back to the Universal Declaration of Human Rights. This goes back to the wonderful words of the Charter. And where did that eloquence come from? Did it come from professors, academics, judges, prosecutors, in abstract putting something down? Or did the prose come from seeing hell and realizing they didn't want that ever to become the reality ever again? I was clear in my messages. And it's important to recall them at the moment when there's so much distrust and heartbreak and sorrow, when there's a risk of unrestrained fury arising out of the belief, sometimes the disinformation, that the structures are not fit for purpose. That's a fundamentally wrong and dangerous assumption. The issue maybe is not the structures, it's the will to enforce and support the structures that are in place. But I was very clear that humanitarian relief, the denial of humanitarian relief, is a matter my office is investigating. It is, and may be, an offence under the Rome Statute, and Israel must allow that humanitarian relief in on scale. As the Secretary General of the United Nations, as the head of the Office for Coordination of Humanitarian Assistance, Martin Griffiths, the WHO, UNRWA, ICRC, all have demanded. I emphasized that when I was at the Rafah crossing in October, when I saw for myself trucks filled up with food and medicine, and yet they were not going to those that needed the anesthetics, the food, or the water. I emphasized that hostages, well, they shouldn't have been taken at all. It's a grave breach of the Geneva Conventions. It's a crime under the Rome Statute. But those hostages taken from Israel must be released immediately. They can't be used as human shields, which also is a crime under the Rome Statute. And I saw, in fact, I met two delegations, Excellencies, of Israelis in The Hague. And I met one grandfather that came to see me about a month ago as part of a delegation. And I met him again 2 days ago. And he was overjoyed that his grandson had been released. And the joy and the relief was palpable, and yet he was with an organization trying to support others. And the pain that Palestinians are feeling in Gaza or in the West Bank, the pain that so many Israelis who suffered on the 7th of October and continue to suffer in the aftermath, is something that is not academic. It's why we have law, why we need you, why you created us and the International Criminal Court. So the stakes cannot be higher, and the relevance of international justice could not be rendered more stark than at this particular moment. And I emphasize that all attacks against Palestinians in the West Bank by Israeli settlers in the occupied Palestinian territories must cease without delay. No individual with an extreme ideology and a gun can feel they can kill or shoot or attack Palestinians with impunity. And I emphasize Israel as an occupying power has fundamental legal obligations to repress, prevent, and punish those crimes, and that we're looking at that as well to make sure their rights are vindicated. And we've all heard a lot. One doesn't need to be an international lawyer now to have heard the terms distinction, precaution, and proportionality. But I emphasize that these are not abstract constructs, they're solid hard law. And they cannot be interpreted in a way that denudes them from any legal effect, that eviscerates from them their core meaning, which is to protect children and women, the old and the infirm, civilian men and civilian children. And at the same time, I emphasized that human shields using civilians is also a crime. So I want to be quite clear that this court and this office is guided by one fundamental principle, which is justice has to be delivered, not based upon emotion. We can't be that self-indulgent, but based upon a common yardstick, which has been set out from the Nuremberg principles, from customary international law, by the Geneva Conventions, and finds form in the Rome Statute that the judges of the ICC ultimately decide. These are active investigations, and I've also announced today that whilst I've been increasing with the very difficult resources and in fact stealing resources from other situations, next year we will have another new member of staff. I appointed a P5 about 5 months ago, but a D1 level that will be leading the Palestine investigations, reporting to me directly as the D1 in Ukraine reports to me directly. And this is because of the complexity of the situation, but also because we can't divert attention from the work that the deputy prosecutors are doing on other situations, because those situations and the victims there deserve progress. They deserve those situations to be properly addressed as well. I emphasized repeatedly to all decision makers in Israel and in Palestine, particularly Hamas, that this is the time when they must comply with the law right now. And if they don't comply with the law right now, nobody should complain later, because we are moving forward with our investigations. But as the tragedy unfolds in Israel and the West Bank and Gaza, we have to show that we have the stamina, the ability, the tools to show that every life matters. And in a few days, I will launch the second annual report of the activities of the office. It will be available online. But the office and the court has been extremely busy. And this new approach that is set out in the strategic plan I launched for 2023 to 2025 is already showing results. We see, since April, the nightmare that is Sudan has returned. It should also be on the front pages, the amount of tragedy. But the office has had multiple missions to the region, is investigating those current actions again. I mentioned at the Security Council that we had jurisdiction there, and we're moving also with focus by these multiple teams on the ground and accelerating our work. In terms of Ukraine, we've built partnerships, we've been working effectively, and the independent judges of the ICC this year issued warrants in relation to President Putin and Madam Lvova-Belova. we're moving forward with the investigation. And again, like in many other situations, like in Gaza, I'm very worried with the onset of winter, very deep and biting in Ukraine, and the attack on power plants and infrastructure. In Bangladesh and Myanmar situation, I visited Cox's Bazar and Dhaka for the second time and met the Prime Minister again. And we've really deepened our relationship with the authorities in Bangladesh, with the United Nations support, and also with our field presence in terms of having longer missions in Bangladesh. And I believe, God willing, next year the results of that will become manifest as we are accelerating the speed of that investigation that's been open since 2019. Afghanistan as well, an obvious case where manifest human rights abuses have taken place, but last year we announced in December, with the excellent work of Lisa Davis, a new policy paper on gender persecution. We're focusing on the situation in Afghanistan, where we see on a massive scale the denial of rights to women and girls, which also may be crimes within the court's jurisdiction. We're investigating that. Across these and other situations, I really do believe, members of the Assembly of State Parties, distinguished delegates, that the results are being felt. We're moving at a new speed with new nimbleness, with greater field deployment, using cutting-edge technology, and deepening our cooperation with civil society. But we're going to continue to deliver more results, being more focused. And since the last ASP, I've announced the closure of the investigative phase in the Central African Republic, in Georgia, and in Uganda. And the Deputy Prosecutor, Nazat Shamim Khan, announced the closure of the investigation stage in Kenya. These are the first time these situations, investigative stage, has been closed. Whilst this may not all be visible yet, this has been the most productive year ever in terms of output by the Office of the Prosecutor, in terms of warrants, public and sealed, issued by the judges of the ICC, in terms of other benchmarks as well. It's been a year of great activity. Complementarity and cooperation has also had many tangible successes. Just in the last 2 weeks, I've engaged with the government and Prime Minister of Iraq, a non-state party, in terms of accountability. 2 days ago in Venezuela, the office signed a work plan with the government of Venezuela for the delivery of support to Venezuelan authorities, including a physical office in Caracas. I'll be signing an agreement during this ASP with the Foreign Minister of Colombia to open a field office also in Bogota. And an example that when I promised that when we closed the preliminary examination, it wouldn't be the end of partnerships, I was true to my word because of the work of the men and women of the office. Last week, Deputy Prosecutor Niang was in the CAR to sign an MOU with the government and the specialized court. He was also in the DRC to follow up on my MOU that I signed in June, and we're continuing to engage in Guinea. We've sent out a policy paper on cooperation and complementarity, and we'll launch today and tomorrow new policy papers on crimes against children and also on gender crimes as well. There's much more I can say, but I want to conclude now with your leave, Madam President. We hear in this building, and we hear in capitals around the world, a constant refrain that there is this wonderful support for the rules-based system, for the principles of public international law, and that the principles of IHL must be respected. Many states have contributed, but respect for these rules means supporting the institutions charged with promoting and protecting them. This is really a critical moment for the ICC, for the United Nations, and all institutions. What we ask for is a chance to deliver. What we ask for are the tools to deliver. We will fail together, but we can and we must succeed together. That's why this Assembly of State Parties is so critical. Thank you so much.
I thank Prosecutor Khan for his statement, and I propose that the Assembly take note of the report of the International Criminal Court contained in document ICC ASP22/22. I see no objection. It is so decided. I would like to take this opportunity to express my gratitude to the Court for the support it has provided to the review mechanism, to various mandates and initiatives of this Assembly, to the Bureau and working groups, and to me personally. I have been in regular consultations with the Court, in particular the President and the Registrar of the Court, to address several issues, some of which rather complex and thorny, that arose throughout this year. So I really thank you for your cooperation. Now, the Assembly has concluded its consideration of Agenda Item 11. And let us now turn our attention to Agenda Item 12, Report of the Board of Directors of the Trust Fund for Victims. The report on the activities and projects of the Board for the period 1st of July 2022 to 30th June 2023 is contained in document ICC ASP/22/14. I now have the honor to give the floor to Ms. Minu Josefina Tavares Mirabal, Chair of the Board of Directors of the Trust Fund for Victims.
Señora Presidenta.
Madam President, dear friend, President of the Court, Your Excellencies, representatives of states parties, good morning. In this century, millions of children, women, and men have been victims of atrocities that defy the imagination and profoundly move the conscience of humanity. That is the text of the second paragraph of the preamble of the Rome Statute that was signed last century, and yet appears that it would be narrating the global destruction that has shaken our souls over the past few days, and that we have heard mentioned once again by the prosecutor of the court. The aspiration to justice in the Rome Statute of the International Criminal Court has as its backbone the path that victims must take in their road to achieve justice. And in this process, they receive information from the Secretariat of the court to have access to justice and participate in processes. They also benefit from programs of reparations in case of guilty verdicts, or of programs of assistance that are available for the victims under the jurisdiction of the court, for which the Executive Board of the Trust Fund for the Victims, with the support of the Assembly, mobilizes resources and designs and implements programs, thus transforming into reality the mandate of reparative justice of the Rome Statute. The priority of the Trust Fund for Victims is to ensure that the reparations ordered by the justices in cases of guilty verdicts are implemented. And I am happy to inform you that on the 9th of October of this year, the fund, as the courtroom was also informed, completed the delivery of reparations, individual reparations, to 297 individuals recognized as beneficiaries in the case of Katanga. These individuals suffered damage 20 years ago in the town of Bogoro in the Ituri province. They had been victims of attacks, counterattacks, destruction of property, and pillaging. It is therefore with this program that has been valued at $1 million that the court is closing for the first time the first case initiated when the Democratic Republic of the Congo referred the situation to the court in 2002. The close of this case will be marked by a ceremony in Bunia next February, and I would invite you to get acquainted with the methodologies of reparations and their impact in the parallel event dedicated to this topic that will take place tomorrow, the 5th of December, Tuesday. In the Democratic Republic of the Congo, the fund has also continued to implement collective programs focusing on individuals for 2,471 former children, soldiers, their families, and other indirect victims related to the Lubanga case. And for this, the court has collected 75% of the $10 million ordered as the financial responsibility of Mr. Lubanga. We would like to make an appeal to states parties so that in 2024 they commit to providing the remaining $2.5 million. This collection should be continued for the victims of the Ntaganda case, for which a financial responsibility for reparations has been established of $31.3 million, and for which the fund is currently designing programs. Now moving on to Mali. I'm also delighted to inform you that as the courtroom was notified on the 27th of October, the Trust Fund for Victims completed the program of individual reparations for 1,450 victims of the attacks against religious and historical buildings in Timbuktu in June and July of 2012. The Trust Fund will continue working in cooperation with the authorities of Mali for the implementation of collective reparations that include the restoration of cultural heritage together with UNESCO, as well as commemorations to address the moral damage caused to the Timbuktu community, and the establishment of socioeconomic mechanisms to restore the damage caused to the economy of Timbuktu as a result of the destruction of its cultural heritage. These cases point to the increasing complexity of the cases dealt with by the International Criminal Court. In the case of Ntaganda and the Ongwen case, the fund will confront one of its greatest challenges to address very serious crimes that it is estimated will affect more than 66,000 people. 66,000 people. We will discuss the challenges of these programs in parallel events scheduled for the 7th and the 8th of December with partners from civil society, including the Coalition for the International Criminal Court and its components. As far as the assistance, the Trust Fund is also implementing other programs for the benefit of victims by providing assistance through medical treatment, psychological rehabilitation, socioeconomic support, education, and peace-building activities, and with a central focus on the victims of gender-based and sexual violence victims. These programs have a daily impact on the lives of victims in 7 situations in the Central African Republic, in the Côte d'Ivoire, in the Democratic Republic of the Congo, in Georgia, Kenya, Mali, and Uganda. All these are covered by the current jurisdiction of the International Criminal Court. In 2022, approximately 17,000 people directly benefited from these programs. But it's also extremely important that we act in a global and impartial manner. The fund is exploring alternatives to tighten the time frames that are necessary to initiate new programs in all situations where our mandate operates. The challenge will be to cover 9 additional situations in a diligent, impartial, and effective way. This is why, in October of 2023, the governing board of the trust fund decided to begin initial consultations to determine the viability of initiating, of course that would be subject to financial, legal, operational, and political considerations, to initiate other programs for the benefit of victims in 9 other situations under the jurisdiction of the ICC where the fund currently does not have any programs. And I'd like to take this opportunity to reiterate once again the invitation conveyed by the Note Verbal in November of 2023 for states parties to make voluntary contributions for this purpose. Now, the Governing Board has also responded to reiterated requests by states parties for us to step up our efforts in fund collection. And we have taken these requests very seriously, and we're proud that during this challenging year, in which we've also managed to carry out a very important change in the leadership of the fund, we have managed to increase by at least 35% the contributions to the fund. Toward the end of this year, these contributions will have been received and benefited some 24 states parties. However, we acknowledge that the general budget continues to be extremely modest and that greater resources are necessary to satisfy the growing needs of victims and on the basis of the significant reparations that have been ordered by the tribunals. This responsibility falls on the Governing Board, of course, but it's also a responsibility that we share with the states parties of the International Criminal Court, and therefore we appeal to them that they must continue their support and increase their efforts both in terms of contributions to the fund for the benefit of victims as well as to strengthen the secretariat that bears the main responsibility for implementing projects. We count on the trust of the Assembly in our management and work. This year we have successfully managed a leadership transition, bringing to the head of our executive board a new executive director. We've implemented a series of significant institutional changes to improve the effectiveness and the impact of the fund. We have developed a new strategic plan that clearly articulates the central role of the trust fund within the very heart of the Rome Statute system. We have developed a new communication strategy with the help of a specific contribution from Ireland, laying the groundwork for increasing the visibility of the fund. This year, it is ending for us, as you can hear, with a lot of hope. For this year, I would like to particularly thank the President of the Assembly who through her good offices, opened new opportunities for the fund, including in cooperation with Switzerland and Japan, and in an iconic ARIA formula session with the Security Council that was focused on victims. As the Executive Board, we also would like to pay a sincere tribute in his last session as President of the Court to Piotr Hofmansky for his outstanding leadership. We'd like to express our deep gratitude also to the Secretary of the Court, Osvaldo Zavala, for the extremely important support that he has provided to the work of the fund. And of course, we'd like to express our gratitude to Prosecutor Karim Khan and his deputy prosecutors for the dialogue that we've initiated with them. Your Excellencies, Madam President, Mr. President, new participants, parties to the court, new members of the Executive Board of the Assembly of States Parties, distinguished representatives. Together, we are making progress towards an international criminal court truly focused on victims, an achievement that is only possible with the continuous political and financial support of states parties. We will persist with determination in this noble task, and we look forward to dialogue, cooperation, and what's most important, the achievement of even more significant results in 2024. Thank you very much.
Muchas gracias.
Thank you very much.
Ms. Tavares Mirabal for her statement, and on behalf of the Assembly, I ask her to convey to the distinguished members of the board the appreciation of the Assembly for their tireless efforts and commitment to provide effective remedy to victims. I now propose that the Assembly take note of the report of the Board of Directors of the Trust Fund for Victims contained in document ICC ASP22/14. I see no objection. It is so decided. We have thus concluded our consideration of Agenda Item 12. Now let us turn to Agenda Item 13, Review of the International Criminal Court and the Rome Statute System. The Assembly has before it the report of the review mechanism submitted pursuant to ICC ASP/21 Resolution 4, which is contained in document ICC ASP/22/11. I will now invite Ambassador Michael Kanu from Sierra Leone to introduce his report from the rostrum.
Thank you, Madam President. Madam President, President of the Court, Judge Ofmansky, the prosecutor, the registrar, the Undersecretary General for Legal Affairs and Legal Counsel, Chair, Board of Directors of the Trust Fund for Victims, Excellencies, distinguished delegates. I have the honor to introduce the report of the review mechanism submitted pursuant to Resolution ICC ASP/21/4, pursuant to paragraph 12. And this report, as read by Madam President, is contained in ICC ASP/22/11. I do introduce this report on behalf of my state party co-chair, Ambassador Paul van der Eysel, and the ad country focal point, Bangladesh, Chile, and Poland. Madam President, permit me to really thank you for the very kind words directed to the review mechanism, and particularly the state party representatives. Our report to the Assembly is submitted further to our initial report this year. That is the report of the review mechanism on the overall progress of its work. The report is dated 30th June 2023, and this report covers the work done in the first part of this year. The present report gives an overview of the work done in the second part of this year, which is referred to as the second semester in the report. Excellencies, in light of the advanced stage of the assessment of the 384 recommendations put forward by the group of independent experts, this was submitted in the final report of 30th September 2020. The review mechanism decided in 2023 to focus on the implementation of the IAR recommendations that have been assessed positively or positively with modifications. During the reporting period, the review mechanism also concluded the assessment of the recommendations for which we allocated itself the recommendations to the review mechanism as a platform for discussions. In section 2A of the report, the review mechanism briefly recalls its mandate, which is contained in resolution ICC ASP/20/3. And in this mandate, we have specific deadlines for the completion of each stage of our work. That is, categorization of the IAR recommendations and the proposal for a comprehensive action plan. I'm pleased to note that the review mechanism completed the categorization of the IAR recommendations and the comprehensive action plan proposed in 2021. The report also recalls the review mechanism's consideration of the comprehensive action plan as a roadmap for the assessment of all the recommendations throughout the review process. We note with satisfaction that the assessment of almost all of the IAR recommendations have been completed this year. Further, much progress has been made on the implementation of all the recommendations assessed positively or positively with modifications. The mechanism wishes to indicate that the assessment of the IR recommendations will be reflected in the matrix, which details the progress in the assessment of the IR recommendations. The matrix, as we've indicated, being a living document, is constantly being updated. The latest updated version for this session will be reflected in Annex 5 of the report. Madam President, in Section 2B, the report describes the work done by the review mechanism as a platform for discussion. It refers to the one meeting that the review mechanism held as a platform for discussion, which was focused on the assessment of outstanding IAR recommendations, specifically Recommendation 365 and Recommendation 160, and this is the second part. With the assessment of these two recommendations, the review mechanism completed the assessment of the recommendations which it had allocated to itself as a platform for discussion. We're pleased as a mechanism that together we've been able to reach this significant milestone. And we have been extremely pleased that the chair of the group of independent experts, Mr. Richard Goldstone, and some of the IR experts and assistants participated in the majority of our meetings this year. As indicated, they participated in their personal capacity and were always willing to share information on their thinking, particularly when it comes to the respective recommendations. I'll now move on to the next section of the report, and this refers to the roundtable that was held by the review mechanism on the recommendations concerning the governance of the Secretariat of Trust Fund for Victims. And these are recommendations 355, 356, and 357. The details of the recommendations and the presentations are contained in the report. I'll move on to another important issue, that is tenure. As a mechanism, we've dedicated a section in the report to the IR recommendations 105 on tenure. In the reporting period, the review mechanism held 2 additional meetings on tenure. The report recalls that this recommendation has been positively assessed by the court and by state parties at the 2 meetings of the review mechanism dedicated to tenure last year. As a result of the positive assessment in 2022, the 21st session of the Assembly, having endorsed the positive assessment of the recommendation, invited the court through the registry in close consultation with the Bureau to develop a detailed proposal for a tenure policy for its introduction as of 1st January 2024 and for the approval of this Assembly. The report sets out the steps that have been taken thus far, and although different views have been expressed by state parties, we take note with delight movement towards convergence in some areas. Considering the views expressed in all of its meetings, the review mechanism will continue its consultation on the issue of tenure with the hope that the Assembly can take a decision on the way forward. To this end, we encourage all interested state parties to approach us as always, and also to continue to consult among yourselves. On Monday, 11th December, as indicated by Madam President, the review mechanism will hold informal consultations specifically on tenure and on the draft resolution, which we had recommended to be a stand-alone resolution on tenure. Madam President, as regards the future of the review mechanism, on 13th November, the mechanism held a meeting on this topic, where state parties commented on the options contained in the review mechanism's paper titled Future of the Review Mechanism. In the paper, we have set out options for continuation of the work on the IR recommendations, having listened carefully to the views expressed by states. I wish to draw to the attention of state parties and all other stakeholders that we'll be having an informal consultation on the review mechanisms resolution, that is on 8th December, and we'll devote some time greatly to the future of the work of the mechanism. On 13th December, that is on Wednesday, we'll have a plenary which will focus on the future of the review mechanism. In our report, we note that it is the decision, and it will be the decision of the Assembly when it comes to the future of the review mechanism. And therefore, we encourage all state parties to contribute to these discussions so we can agree to an outcome for the future of the mechanism. Madam President, the report concludes by recommending the adoption of 2 resolutions on the review mechanism and on tenure policy. We once more encourage all state parties and other stakeholders to participate in the facilitation of the 2 draft resolutions, one that will focus on the review mechanism and the other that will focus on the tenure policy. At this juncture, Madam President, in the past 2 years, the Assembly may have been accustomed to the tag team of state party representatives, Ambassador Van der Eysel and I, presenting the report of the review mechanism. Therefore, allow me to take this opportunity on behalf of my co-chair of the review mechanism, Ambassador Paul Van der Eysel, who will arrive in New York later this week, and the 3 ad-country focal points, Bangladesh, Chile, and Poland, to express really a deep gratitude to you for your continued and constant support, your ready availability and guidance, and really for prioritizing this issue which is of interest to all. I also take this opportunity to thank your Vice President and also members of the bureaus and state parties and stakeholders, particularly civil society, for engaging and collaborating with us. Madam President, by prioritizing the review process, you have indeed led by example in ensuring that we strengthen the court. We are also grateful to the court focal point, Mr. Hirab Abtai, Mr. Mamadou Racine Lai, and Mr. Owen Escudero for always being available for our discussions and meetings. This concludes my introduction of the report, and I thank you, Madam President, for the floor. Thank you.
I thank Ambassador Michael Cano for the introduction of the report, and I would also like to thank him and Ambassador Paul van den Eysel, as well as the other members of the review mechanism for their tireless efforts in fulfilling their crucial mandate. We shall revert to this agenda item at our plenary meeting on the morning on Wednesday, 13 December. The Assembly will now begin its consideration of Agenda Item 7. In accordance with Rule 25 of the Rules of Procedure, a credentials committee consisting of representatives of 9 state parties shall be appointed at the beginning of each session on the proposal of the President. After broad consultations with state parties, I propose that the Credentials Committee consist of the following states: Bulgaria, Czech Republic, Finland, Ghana, Mexico, Netherlands, United Republic of Tanzania, and Venezuela. May I take it that the Assembly agrees to proceed accordingly? It is so decided. The Assembly will appoint the remaining member of the committee at a later meeting. I wish to remind representatives that pursuant to Rule 25 of the Rules of Procedure, credentials shall be submitted to the Secretariat if possible not later than 24 hours after the opening of the session. Credentials shall be issued by the head of state or government or by the Minister for Foreign Affairs or by a person authorized by either of them. Before we move on the next agenda item, I wish to indicate that the Bureau decided to recommend that the Assembly appoint Mr. Abdou Ndoye as rapporteur for the 22nd session. Does the Assembly agree to the appointment of Mr. Abdou Ndoye of Senegal as rapporteur for the 22nd session? I see no objection. It is so decided. We shall now turn to agenda item 8, organization of work. The Bureau has considered the program of work, which is reflected in the ASP journal dated 1st December 2023. The Bureau proposes that this program form the basis of our work for this session. I trust that you will understand that the program of work may be subject to modification depending on the progress attained on the different items. I would ask each representative to ensure to arrive on time to the meetings in order for the Assembly to complete its consideration of all items on its agenda for the 22nd session. May I take it that the Assembly decides to adopt the program of work reflected in the ASP journal dated 1st December 2023? I see no objection. It is so decided. As proposed by the Bureau, the Assembly will meet in plenary session and will hold informal consultations on some key issues on which decisions must be taken. At its first 7 September 2023 meeting, the Bureau recommended that the following representatives serve as coordinators for the 22nd session. For the Working Group on the Program Budget for 2024, Ambassador Ksenia Milenkovic of Serbia. For the informal consultations on the Omnibus Resolution, Ms. Alexandra Hutchison, Australia. Moreover, in light of the fact that negotiations on some additional topics have not yet concluded, I propose that we also appoint the following representatives to serve as coordinators for the 22nd session. Ambassador François Alabrune from France and Ambassador Momar Gueye from Senegal. For the composition on the Committee on Budget and Finance, Ms. Shahanara Monica from Bangladesh. May I take it that the Assembly wishes to proceed on this basis? I see no objection. It is so decided. I congratulate Ambassador Ksenia Milenkovic, Ms. Alexandra Hutchison, Ambassador François Labrune, Ambassador Momar Gueye, and Ms. Shahanara Monica, and I wish them every success as they carry out their responsibilities. I wish to assure them that they can rely on the Bureau to provide any guidance that may be necessary. States in arrears. The Assembly will now turn to this agenda item 6. According to Article 112, paragraph 8 of the Rome Statute, a state party which is in arrears in the payment of its financial contributions towards the costs of the court shall have no vote in the Assembly and in the Bureau if the amount of its arrears equals or exceeds the amount of the contributions due from it for the preceding 2 full years. The Assembly may nevertheless permit such a state to vote in the Assembly and in the Bureau if it is satisfied that the failure to pay is due to conditions beyond the control of the state party. The Secretariat sent a note verbal dated 8 November 2023 to all concerned states via their United Nations missions, as well as their embassies in The Hague and Brussels, informing them that they were in arrears, stating the minimum payment required to avoid the application of Article 112, paragraph 8 of the Rome Statute, and indicated that any state party wishing to request a waiver from the loss of voting rights should submit the request to the Bureau of the Assembly through the Secretariat by 28 November. In accordance with information provided by the Court, it would appear that Article 112, paragraph 8 of the Rome Statute is currently applicable to 13 states parties. The Bureau received requests for a waiver from the loss of voting rights for the 22nd session of the Assembly from the following state parties: Antigua and Barbuda, Central African Republic, Chad, Comoros, the Republic of Congo, the Democratic Republic of Congo, Gabon, Guinea, Liberia, Namibia, Venezuela, and Zambia. The Bureau decided to recommend that the Assembly grant requests for waivers from the loss of voting rights at the 22nd session. At the same time, the Bureau recommended that it develop criteria in order to better equip the Assembly and the Bureau to assess such requests in the future. On this understanding, may I then take it that the Assembly agrees to exempt Antigua and Barbuda, Central African Republic, Chad, Comoros, the Republic of Congo, the Democratic Republic of Congo, Gabon, Guinea, Liberia, Namibia, Venezuela, and Zambia from the loss of voting rights? I see no objection. It is so decided. I would also like to invite the other state party that is subject to Article 112, paragraph 8 of the Rome Statute, namely Dominica, to submit a formal request to the Assembly of State Parties via the Secretariat if it wishes to request a waiver from the loss of voting rights. I would also like to stress once again the importance of ensuring that the court is provided with the necessary financial resources. The state of arrears and the liquidity issues facing the court are matters of great concern. I encourage all state parties to transfer their assessed contributions in full and on time, or in the event of pre-existing arrears, immediately, in accordance with Article 115 of the statute and Rule 105.1 of the financial regulations and rules. I understand that the delegation of Venezuela has asked for the floor. Venezuela, you have the floor.
Muchas gracias, señor.
Thank you very much, Madam President. Given that this is the first time that my delegation is taking the floor at this 22nd meeting of states parties to the Rome Statute, I would like to express to you and the rest of the Bureau our wishes of success and our congratulations. You will have our full support, and we believe that your success will lead to strengthening the rule of law at the international level and to promote and protect all human rights and fundamental freedoms, in line with the spirit of the Rome Statute. Madam President, the Bolivarian Republic of Venezuela is a responsible member of the international community. That is why our delegation wanted to take the floor under this particular agenda item, because we think it is critical to make it clear for the record our determination and full availability of our state to honor, in a full and timely manner, our financial commitments to the ICC regular budget. Nevertheless, I would like to recall to this Assembly of State Parties that since at least 2014, our country has been subjected to a financial, commercial, and economic blockade, with the illegal implementation of more than 930 unilateral coercive measures. These are quite clearly a flagrant violation of international law and all norms, including the principles of the Rome Statute. And that, indeed, led to our country in February 2020 carrying out referring the situation to the ICC. This is the so-called Venezuela 2 file, whose goal is just to ensure that those responsible for these crimes against humanity that are being committed against our people today be held accountable under international justice. Madam President, these criminal measures are a collective punishment against 30 million Venezuelans. This has led to economic losses to the tune of more than $30 billion. These measures have prevented the state of Venezuela since 2014, when they began, when this multifaceted aggression against our country began. This has prevented us from carrying out our payments to the ICC, even though we wish to do so, and we have the resources, in theory, to do so. Many efforts have been made since then to try to resolve the situation, as the prosecutor's office of the ICC have recognized, and we have been in constant communication with them on this matter. To date, nevertheless, it has not been possible for us to find a necessary financial route to allow for the requisite funds to be transferred to pay off our debt, a route that ensures that they will not be held, frozen, or confiscated under these so-called sanctions, which are criminally applied against our country. Madam President, in spite of this reality, which is the result of actions and policies that are quite simply beyond our control, the Bolivarian Republic of Venezuela would once again like to restate its unwavering commitment to continue all possible measures to ensure that this unfortunate situation is resolved as soon as possible. And we conclude by welcoming the decision that was recently taken on this matter, which is not only in line with the provisions of Article 112.8 of the Rome Statute, but it clearly shows the understanding of states parties of this Assembly about the challenges that my country is currently facing as a result of a range of interfering policies that undermine the rule of law and attack the full enjoyment of my people's human rights. This has led to a widespread crisis, which, as has clearly been shown, affects countries subjected to them, and indeed all other members of the international community as well. And this includes the work of the ICC itself. Thank you very much.
Muchas gracias, y doy la palabra a Canadá.
Thank you, Madam President. I have the honor to speak today on behalf of Japan, Slovakia, and my own country, Canada. Madam President, the state of arrears and the recurring threats of a potential liquidity crisis facing the court each year is profoundly concerning. Although Japan, Slovakia, and Canada are satisfied with the payment by some states parties of their arrears earlier this year, greater efforts must be made by all. The court's success depends on the timely payment of contributions. Being a state party is a privilege and comes with responsibilities which all must respect. We acknowledge the costs associated with the court's growing workload and recognize its need for an appropriate budget. On the other hand, atrocity situations worldwide are on the rise, increasing the potential workload of the court. If left unaddressed, the situation will only deteriorate further. Madam President, Japan, Slovakia, and Canada have taken note of the requests for waivers of loss of voting rights received again this year. We appreciate the interest shown by states parties to participate in the court's elections and welcome this willingness of all to engage. Nonetheless, we also noted that for some of these countries that have filed such a request, the minimum payment to be paid to regain their right to vote is as little as €1. I repeat, Madam President, as little as €1. We understand that these amounts, which serve as a gesture of good faith to the Assembly, have not been paid. This process of granting waivers was never meant to be a permanent solution, but rather a way of helping states facing significant economic hardship. Last year, we suggested language within the Omnibus resolution to increase the cap of the Working Capital Fund to ensure that arrears paid to the court stay with the court. This year, Japan, Slovakia, and Canada remain committed to engaging constructively with other states parties to finding lasting solutions and ensure continuous financial support for the court. Thank you, Madam President.
I thank you. Does any other delegation wish to take the floor at this point? I see none. We take note then of the statements that were made on this agenda item. I thank you very much. And now we turn to agenda item 15, election of 6 members of the Committee on Budget and Finance. The 6 vacancies that will arise on the committee on 31st December 2023 upon the expiration of the terms of office of 6 members are as follows. African states, 1 seat. Asia Pacific states, 2 seats. Eastern European states, 1 seat. Latin American Caribbean states, 1 seat. Western European and other states, 1 seat. Since the number of candidates corresponds to the number of vacancies in the regional groups concerned, the Bureau, pursuant to Resolution ICC ASP/1/Resolution 5, decided to recommend that the Assembly elect the following candidates by acclamation. African Group, Ms. Sanyu Diana Awori, Kenya. Asia Pacific States, Mr. Fauzi Garaibeth, Jordan, and Mr. Yun Yamada, Japan. Eastern European Group, Ms. Elena Sobkova, Slovakia. Latin American and Caribbean Group, Ms. Mónica Sánchez Izquierdo, Ecuador. Western Europe and Other State Group, Mr. Werner Drummel from Austria. Does the Assembly wish to elect the above-mentioned candidates by consensus for a 3-year term commencing on 1st January 2024? I see no objections. It is so decided. I congratulate the members of the Committee on Budget and Finance on their election. We have thus concluded our consideration of Agenda Item 15. I now turn to Agenda Item 3, election of the President for the 23rd to 25th sessions. In accordance with Rule 29 of the Rules of Procedure of the Assembly of State Parties, as amended by Resolution ICC ASP/12/Resolution 8 Annex 3, unless the Assembly decides otherwise, the Assembly shall elect a President at the regular session marking the end of the term of office of the Bureau. The President so elected shall assume his or her functions only at the conclusion of the session at which he or she is elected and shall hold office until the end of his or her term. Distinguished delegates, on 26 November 2023, the Bureau decided to recommend to the Assembly that Ambassador Päivi Kaukoranta from Finland be elected as President of the Assembly of State Parties to the Rome Statute of the International Criminal Court for the 23rd to 25th session of the Assembly. Could I suggest that we now proceed to elect Ambassador Päivi Kaukoranta from Finland by acclamation? I see no objection. Ambassador Päivi Kaukoranta from Finland is hereby elected by acclamation President of the Assembly for the 23rd to 25th session. I wish to congratulate Ambassador Päivi Kaukoranta and invite her to the rostrum to take the floor.
Madam President, Excellencies, representatives of the Court, Legal Counsel, and the Chair of the Board of Trust Fund for Victims, distinguished delegates, and the representatives of the civil society. At the very outset, I would like to sincerely thank you for the support and confidence entrusted with me upon my election as President of the Assembly of States Parties for the upcoming 3 years. I am grateful to the Western Europe and Others Group for designating me for this position. It is a great privilege and responsibility to serve as President of this Assembly. It is almost 30 years since I participated in the first preparatory meetings of the Rome Statute here in New York, and I promise to continue in this role with the same devotion as that young lawyer did. My deepest appreciation to you, President Silvia Fernandez de Gurmendi, and to your Vice Presidents, Ambassadors Katerina Sekvensova and Robert Ray, for the valuable guidance and support when preparing for this position. I congratulate you for your successful leadership in advancing the interests of this Assembly and the system of international criminal justice that extends beyond this Assembly. I'm humbled when looking at the achievements of the previous bureaus in consolidating and developing the court and the Rome Statute system. I also take this opportunity to thank the outgoing President Piotr Hofmansky and the outgoing judges of the court already now for their excellent work, and wish good luck for the candidates in the upcoming elections. The 25th anniversary of the Rome Statute is an important milestone. As a judicial institution, the court is still young, but has already gained a wealth of important experience and success in investigating and trying most serious crimes that the states themselves are unable or unwilling to deal with. Court needs cooperation by states, and states parties shall do their part in order to enhance an effective and efficient court. During the past years, a lot of work has been done on the basis of the independent expert review in order to optimize the functioning of the ICC while safeguarding its independence and integrity. The review process should not be seen as one-off exercise. We should continuously work together to strengthen the court and the Rome Statute system. I am delighted by the recent ratification of the Rome Statute by Armenia, which brings the number of states parties to 124. Work towards the universality of the court needs to continue. I commit to continue the excellent work of my predecessors in this regard and invite all of you to join these efforts. The rights of victims are at the heart of the Rome Statute system. This unique feature allows the victims and survivors participatory rights beyond the status of witnesses. Victims and survivors have a right to be included in the proceedings and have their views and testimonies to be heard. They also have a right to assistance and to court order preparations, where the Trust Fund for Victims plays an essential role. All of these aspects are at the heart of the victim-centered approach to international criminal justice as embodied in the Rome Statute. As the work of the court has progressed and expanded, it has also faced challenges and opposition. The political attacks against the court and its officials, such as the ones we have witnessed in the recent years and referred to by the statements of the President of the Assembly and the President of the Court today, they are unacceptable and should be denounced by all states parties. The court, now more than ever before, needs the full support and cooperation by states parties in order to safeguard its integrity and independence. Madame la Présidente, l'année dernière, l'Assemblée de cet parti adopté.
Last year, the Assembly of State Parties adopted a new strategy to respond to threats against the ICC. I am grateful for the responsibility to coordinate an appropriate response from the Assembly against any threat against the court which could jeopardize its effectiveness, its integrity, or its impartiality. Threats to security that the ICC is currently facing are a common and serious concern. I acknowledge the guidelines and recommendations that have been recently adopted to improve the security of participants to the Assembly's work. Together with the new Bureau, I hope to continue this important work. In 2010, the Kampala Conference decided to review amendments pertaining to the crime of aggression, 7 years after the court began its jurisdiction over this crime. The beginning of the jurisdiction in 2018 led to the review of this issue. The President serves at the behest of the Assembly, and I will be in favor of a shared understanding of the process and the result of the review. I look forward to working together with the new Vice Presidents, all members of the Bureau, and with you, dear members of the Assembly of States Parties. My door will always remain open to you. I will, of course, engage with you here in New York and in The Hague and in your capitals for your support in this work, and I hope that you will not hesitate to do likewise when you wish to raise issues that require the attention of this Assembly. I will use all tools available to me to maintain the inclusivity of this Assembly, to allow all delegations to participate fully in its work, and also to ensure space for civil society. As President of this Assembly, I will do my utmost to promote mutual understanding in decision-making. I look forward to cooperating with the United Nations and other international organizations, as well as, of course, with the ICC. I thank the Secretariat of the ASP in advance for their continued support that they provide to the Presidency and the Assembly as a whole. Thank you for your attention.
I thank Ambassador Päivi Kaukoranta for her statement and wish her every success in the performance of her duties. Distinguished delegates, pursuant to Rule 29 of the Rules of Procedure of the Assembly shall proceed to complete its Bureau by electing 2 Vice Presidents and 18 members of the 23rd to 25th sessions. As indicated in the annotated agenda as its 3rd session, the Assembly agreed on the following composition of the Bureau. Group of Western European and other states and group of African states, 5 seats each. Group of Latin American and Caribbean states and group of Eastern European states, 4 seats each. Group of the Asia Pacific, 3 seats. The Bureau decided to recommend that the following states be elected as members of the Bureau for the 23rd to 25th sessions. African Group, Kenya, Senegal, Sierra Leone, South Africa, and Uganda. Asia Pacific Group, Cyprus, Japan, and Republic of Korea. Eastern European Group, Bosnia and Herzegovina, Latvia, Poland, and Slovenia. Latin American and Caribbean Group, Bolivia, Brazil, Chile, and Ecuador. Western European and other states group, Belgium, Finland, Italy, New Zealand, and Switzerland. May I take it that it is the wish of the Assembly to elect Belgium, Bolivia, Bosnia and Herzegovina, Brazil, Chile, Cyprus, Ecuador, Finland, Italy, Japan, Kenya, Latvia, New Zealand, Poland, Republic of Korea, Senegal, Sierra Leone, Slovenia, South Africa, Switzerland, and Uganda as member of the Bureau for the 23rd to 25th sessions? I see no objection. It is so decided. I also understand that there is an agreement to elect Ambassador Michael Kanu from Sierra Leone and Ambassador Margareta Kasangana from Poland as vice presidents of the Assembly. May I take it that it is a wish of the Assembly to elect Ambassador Michael Kanu and Ambassador Margareta Kasangana as vice presidents of the Assembly? I see no objection. It is so decided. I wish to congratulate Ambassador Michael Kanu, Ambassador Margareta Kasangana, and all the members of the new Bureau. I am fully confident that they will successfully fulfill the important mandate entrusted to them. We have thus concluded our consideration of Agenda Item 4. Distinguished delegates, we have concluded our business for the first plenary meeting. We will meet here at 15 hours sharp, 3 p.m. sharp, to begin the election of 6 judges of the court. I wish to announce that the Credentials Committee will meet immediately following the adjournment of this meeting in Conference Room F. Conference Room F. I wish you all a pleasant lunch break and see you back here at 3 p.m. This meeting is adjourned.
Well done.